Welcome back. Today, we're diving into a brand new explainer, and we are going full analytical engine on this one. We're breaking down the complex, expert-level legal framework that governs removal defense. We're going to strip away the surface-level storytelling and emotional narratives that usually surround this topic, and instead expose the underlying statutory logic. We'll be looking at the strict rules, the hidden mechanisms, and the cause and effect relationships that dictate who gets to stay and who must leave under the law. Get ready to understand this complex administrative machine like never before. We will isolate the variables, examine the evidentiary thresholds, and map the precise legal parameters that adjudicators must strictly follow.
Okay, let's dive into this blueprint mapping the categorical structure of the administrative proceedings today. We'll start with the removal defense framework, then move into the statutory elements of asylum, burden shifting and presumptions, the inverse protection paradox, anti-torture protection parameters, and finally, statutory bars and ineligibility. Section 1, the removal defense framework, focusing on the binary inquiry of the administrative system. This entire legal architecture starts with a really rigid, non-negotiable question. It's a strict cause and effect relationship. Step 1 is legal removability. The judge or adjudicator has to first figure out, is this individual even legally subject to removal? The burden is entirely on the prosecuting authority here to prove that the person shouldn't be in the country. And hey, if the government fails that step, boom, the proceedings terminate right there. But if they do prove removability, that's the only time the system moves to step 2, eligibility for relief. So the secondary question of protection literally cannot be triggered until that first question gets a definitive yes. So the crucial point here is understanding the semantic distinction between fighting a charge and asking for relief. Fighting the initial charge basically means saying, the government is wrong, I have a legal right to be here. But seeking relief, that's entirely different. Seeking relief is essentially admitting, okay, the government is right, I am technically removable under the law, but there is a superseding statutory reason why you absolutely cannot send me back. So relief isn't a defense against the charge itself, it's a separate, subsequent plea for safety. Once you enter this relief phase, the whole legal posture fundamentally shifts. The applicant is no longer contesting the state's right to deport them generally, but instead, they're invoking a specific statutory exception to block deportation to one specific territory. Moving on to Section 2, Statutory Elements of Asylum. This is the primary protection mechanism. Now, you might be wondering how someone actually gets this primary protection. Well, it's not handed out just because a particular country happens to be dangerous. An individual has to meet a highly specific legal definition. And the absolute most critical, actionable insight in this whole phase is a concept known as nexus. Basically, nexus requires a direct link. A person can suffer horrific harm, and they can even belong to a protected class. But, and this is a big but, if the judge decides the harm wasn't specifically because of that protected characteristic, the whole legal claim just completely collapses. The protected ground must be at least one central reason for the persecution. It doesn't have to be the only reason, sure, but it can't just be incidental or secondary to something else, like personal vengeance or general crime. If that causal chain breaks, the claim fails entirely. So what actually are these protected grounds? Well, the statute lays out exactly 5, no more, no less. Race, religion, nationality, political opinion, and membership in a particular social group. That last one, particular social group, it is heavily litigated. It is definitely not a catch-all category. To actually qualify, the group has to pass some really strict legal tests. They have to demonstrate immutable characteristics, meaning a trait that members literally cannot change or shouldn't be forced to change, and they need distinct recognition. That means the society in question actually perceives them as a distinct, specific entity, not just some random arbitrary collection of victims. Also, the legal definition of persecution holds a massive implicit assumption that actually surprises a lot of people. Things like general violence, rampant crime, or really severe economic hardship in a host nation, they do not legally trigger this primary protection. It's tough, but the statute simply isn't a general humanitarian catch-all. Legally speaking, persecution requires severe harm that is inflicted with the specific targeted intent to punish someone for having one of those 5 protected characteristics we just talked about. All right, Section 3, burden shifting and presumptions. Let's look at the mechanics of relocation and fear. And this brilliantly illustrates where the legal mechanics get truly fascinating. In this administrative framework, proving one specific element can legally force the opposing side to prove another. It's kind of like a high-stakes game of legal ping pong. Check out how the identity of the persecutor instantly flips the legal burden of proof when it comes to internal relocation. If the persecutor is the government itself, the law just presumes you can't safely relocate anywhere inside that country. So the burden completely shifts to the prosecuting authority to prove that you can. But let's say the persecutor is a private entity, like a gang or some rogue group. In that case, the law actually presumes you can just pack up and move to another city, and the burden lands squarely on you, the applicant, to prove that relocation is impossible or unreasonable. We actually see a really similar mechanical trigger with past harm. Establishing past persecution acts as a massive catalyst. It essentially handcuffs the government by triggering what's called a rebuttable presumption that the applicant has a well-founded fear of future harm. So the applicant basically gets to sit back, and the prosecuting authority is now forced to produce evidence to rebut that presumption. They have to prove either a fundamental change in the country's conditions or that safe and reasonable internal relocation is possible. This trigger is highly strategic. By proving past harm, the applicant forces the government to do all the heavy lifting of proving the country is suddenly safe. Section 4. The inverse protection paradox. High burdens, lower benefits. Okay, we're getting into what is probably the most fascinating, non-obvious detail of this whole system. A total mismatch between the required standard of proof and the actual relief granted. Let's start with this number right here, 10%. To qualify for primary relief, which is asylum, an applicant only needs to establish a well-founded fear. Courts have interpreted this legal term to mean a mere 10% chance of future persecution. Mathematically speaking, that is a really low evidentiary threshold. Yet it grants the most robust, powerful legal benefits in the entire system, including a direct path to permanent residency. Now, what's really interesting about this slide is how the system handles the secondary fallback mechanism, which is called withholding of removal. If you don't qualify for primary relief, this is what you aim for. But to get it, the legal threshold abruptly skyrockets to greater than 50%. You literally have to prove it is more likely than not that your life or freedom would be threatened. So here it is, the inverse protection paradox explicitly detailed. Primary relief has that low, roughly 10% burden of proof, but it's discretionary, meaning a judge can still technically say no, and it offers full benefits. Secondary withholding, on the other hand, demands that drastically higher, more likely than not standard of proof. But if you actually meet that high bar, the grant is mandatory. The catch? The legal benefits decrease significantly. It doesn't give you a green card, it just prevents the government from removing you to that one specific dangerous country. You could still totally be deported to a safe third country. So, as the evidentiary burden increases mathematically, the granted benefits decrease. It's a totally counterintuitive architecture. The hardest protection to win yields the weakest long-term stability, but because it's mandatory, it strips the adjudicator of the power to say no if the facts meet the threshold. Moving on to Section 5, anti-torture protection parameters, the absolute baseline of safety. All right, we've reached the absolute bottom layer of what we can call the funnel of protection. And this part is dictated not by standard domestic immigration law, but by international anti-torture treaties. To really grasp this, we need to surgically separate some casually conflated terms. Legally, torture is completely distinct from persecution. Torture absolutely requires official government involvement. But, and this is key, that involvement doesn't necessarily have to be active. The legal framework recognizes something called willful blindness. This means if a public official simply knows a private third party is committing severe harm and consciously chooses to look the other way, breaching their legal duty to intervene, that passive acquiescence satisfies the strict government action requirement. Let's break down these strict parameters. You need that high, greater than 50% probability of torture. It must involve severe physical or mental pain or suffering, and it has to be intentionally inflicted for a specific prescribed purpose, like getting a confession or punishment. Plus, as we just discussed, it demands government instigation, consent, or acquiescence. But notice the massive semantic distinction at the very bottom here. It drops the nexus requirement completely. To get anti-torture protection, you absolutely do not need to prove the harm is tied to your race, religion, or social group. The system trades away that nexus requirement in exchange for a massive extreme evidentiary hurdle regarding the severity and purpose of the harm. The implicit logic here is that torture is so universally abhorrent that the international legal framework simply ceases to care why it's happening. It only cares that it's happening at the hands of the state. Let's move to and see how this builds into a perfect synthesis. This table really illustrates that funnel of protection we've been talking about. It's this perfectly calibrated sliding scale of legal requirements versus systemic obligations. Look at primary relief. Mathematically easier to prove, but highly discretionary. As you slide down the funnel to secondary withholding, the standard of proof spikes to over 50%, but discretion vanishes. It becomes mandatory. By the time you hit anti-torture protection at the very bottom, the requirement to tie the harm to your personal identity completely disappears. The architecture literally trades access for certainty. Finally, Section 6, statutory bars and ineligibility. What happens when standard relief is blocked? So, what actually happens when an individual simply isn't allowed to access the upper tiers of this funnel? Well, the legal framework contains strict statutory hurdles that act like absolute circuit breakers. They instantly neutralize a claim, regardless of how terrified the applicant is or how likely the persecution might be. Miss the one-year filing deadline? Your primary relief is gone. Got a particularly serious criminal record, or deemed a security threat, or participated in persecuting others? The law slams the door on both primary relief and secondary withholding. You are statutorily blocked from standard protection, entirely short-circuiting the normal evidentiary analysis. There's just no way around it. But here is the fascinating implicit logic embedded at the absolute floor of the system. When those statutory bars block literally every other avenue, mandatory deferral of removal under anti-torture treaties still remains. It is the absolute non-derogable baseline. The framework acts as a final, ultimate safety net. It essentially operates on the principle that the state will flat out refuse to return an individual to face intentional, government-sanctioned severe pain, even if that individual is deemed a danger to the community and is utterly ineligible for all other societal benefits. Which leaves us with this final, provocative thought to ponder. If these statutory bars successfully and correctly identify individuals who have committed serious crimes or who pose severe security threats to the host nation, why does the administrative system deliberately retain mandatory deferral of removal for them? It forces us to realize that at the very bottom of this complex clinical statutory framework, there lies a profound moral absolute that the state's complicity in returning a human being to face certain torture is a line the legal architecture simply will not cross. Thank you so much for joining me for this explainer today, and keep questioning the frameworks around you.